particular respects to all First Nations people attending this panel session. Let me welcome first Jeff Redding, Senior Research Fellow at Melbourne Law School and a New Generation Network Scholar at the University of Melbourne's Australia-India Institute, whose book we will discuss. And our esteemed panellists, Professor Farah Ahmed from Melbourne Law School and Associate Professor Rohit Day from Yale University. You will find their biographical details on our website, along with the recording of this webinar when it's finished. Now, let's turn to Jeff. Jeff, congratulations on this publication of this fabulous book. Would you give us an overview of the book's main arguments and findings?
Thanks so much to the Asian Law Center for hosting this event, and thanks so much to Farah and Rohit for very graciously serving as commentators. So let me just begin by saying that at its heart, my new book, A Secular Need, is an attempt to understand why Muslims and their legal conventions continue to be so politicized in post-partition India. At this point in the 21st century, we are so accustomed to hearing news reports and stories about anti-Muslim violence and discrimination in India that I think that this situation can almost seem normal to many people. So for example, Babri Masjid, Gujarat, cow lynchings, Kashmir, the recent riots and killings of Muslims in Delhi, and the even more recent blaming of Muslims for India's COVID-19 crisis. This drumroll of incidents over the past 3 decades is just natural for many people at this point. There seems to be an attitude almost like, but of course India will be like this. I mean, Pakistan is just as bad vis-a-vis Hindus. I have to confess, however, that I've always found this anti-Muslim sentiment in India to be so bizarre. By way of entry into this topic, and because, and only because Pakistan keeps on being brought into the Indian discussion by both Hindu and secular nationalists, let me just remind everyone that partition happened nearly 80 years ago. That's more than 2 generations ago. And yes, during partition, many Muslims did leave India to the newly created country of Pakistan. Many stayed, however. And yes, Pakistan could have been perceived as a geopolitical threat to India for at least a couple of decades after 1947's partition. But by the 1990s and 2000s, Pakistan had suffered so much with after effects of both the civil war and the state's alliance with disastrous US foreign policy games in Afghanistan, that Pakistan was routinely called a failed state by many commentators, including many Indian politicians and leaders. Yet all that being the case, if you listen to Indian nationalists, they appear to be fundamentally afraid, not only of Pakistan, but also of India's Muslims, who they stupidly, and in a bigoted and hateful way, frankly, label Pakistan's agents. At the same time, another strand of explicitly Hindu nationalism, but which is also endorsed by the secular state, insists that India's Muslims are actually Hindus, and that because Hinduism is so loving and so tolerant, that it is able to accept Islam and Muslims as members of the Hindu flock. In short, this entire situation, while longstanding and now obvious to many people, is in fact, I think, not very intuitive, not normal, and for me, as a scholar especially, demanding of some sort of exploration and moreover, explanation. At the very least, I think we need to think really hard about India's politics of radical exclusion and hate of Muslims, and simultaneously radical inclusion and love of Muslims. My book then attempts to understand this discordant hate-love politics while observing that there is another more subterranean voice speaking here too, one in which the secular state can be heard saying to Muslims, "I need you." In short, my book argues that Indian secular governance hates and loves Muslims and their legal institutions and legal conventions because the state so very much depends upon and needs them. A secular need then uses different case studies to explore the different kinds of need that the secular state has for Muslims and their legal institutions and conventions. These needs are both ideological and material in nature. So for example, private Muslim courts in India perform divorces for Muslim women that the secular state is uncomfortable performing itself, but nonetheless needs done if the state is going to remain a member in good standing in the global club of so-called modern secular states. Less ideologically and more materially, it is well known that the secular Indian states' courts are absolutely overwhelmed by unrelenting caseloads. What is not well known and appreciated is that Muslim courts do a substantial amount of dispute resolution and divert a number of cases that would otherwise consume the state. Moreover, the Indian state has publicly commended these Muslim courts for doing this helpful work. In my book's conclusion, I looked to the future of secular Muslim relations in India. I am certainly not optimistic in this conclusion, but I'm also not completely despairing. That being said, this conclusion was written before the bifurcation and dissolving of the Muslim-majority state of Kashmir, and also the anti-Muslim mob killings that happened in Delhi just a few months ago, and the even more recent blaming of Muslims for spreading COVID-19 in India through their so-called irresponsible religious gatherings. In all these developments, the accusations that Muslims are disease spreaders is perhaps the most troubling and the most indicative that India is on the verge of genocidal fascism. The echoes here of how Jews were characterized by anti-Semites in Nazi Germany are impossible to not hear. If I can still offer something, however, that is just short of less than complete despair, let me simply observe that COVID-19 is offering up a quick and deadly rebuke to macho states invested in their alleged potency. That an enemy can be so vigorous yet so invisible is a humbling lesson for these kinds of states, India included. Moreover, that the state needs the widespread cooperation of its citizens to end this plague, including severely marginalized citizens who have little reason to be invested in the state, has got to be enraging for these states. Put another way, it is not surprising that secular India, under COVID-19, continues to be a hateful state, a loving state, and moreover, a very needful state. Thank you.
Thank you, Jeff. Now let me turn to Farah. Farah, you've worked extensively on Indian personal law and religious freedom, amongst your other achievements. We're very interested to hear your comments and questions.
Thanks so much, Sarah. It's a great pleasure for me to comment on this insightful, original, and highly compelling book, A Secular Need. Congratulations to Jeff Redding on a very significant achievement. Now, this is a very unsettling book. It will provoke, annoy, and shock many readers in the best possible way. So I want to begin my comments by first noting two ways in which the book unsettles or disrupts contemporary discourse on Muslims and Islamic legal practices in India. I will then offer a question and a comment on the book's overarching thesis. The first way in which the book is disruptive is that it unsettles the dominant view of the significance of Islamic legal practices in secular states. As the book notes, across the world, in Australia, in the UK, in Canada, as well as in India, bodies which grant women Islamic divorces and decide disputes using Islamic norms are surrounded by controversy. These bodies are variously known as Sharia courts, Sharia councils, Islamic tribunals, Darul Qaza, Jamaats, and so on. And they are now widely discussed in both scholarship and public debates. The UK has even seen a parliamentary inquiry into Sharia councils, which gives you a sense of how controversial these bodies are. Currently, across jurisdictions, these bodies are taken as evidence that Muslim citizens do not see themselves as really belonging to the larger political community in which they are situated. In other words, when Muslims establish or resort to such bodies, it's taken as a sign of their rejection of the broader British, Indian, Australian, or Canadian political communities. But Redding invites us to think about these bodies very differently. He offers a historical account of the Darul Qazas or Muslim courts in India, and he argues that these non-state bodies, and I'm quoting from the book now, represent the possibility of an India that large numbers of Muslims desire, rather than a place where poverty and fear detains them. He also argues, and I'm quoting again, the creation of a Darul Qaza network represented the possibility that an independent secular India could serve as a home for South Asia's Muslims, rather than merely being a way station to a more welcoming Pakistan. So Redding is inviting us to think of non-state courts and Islamic bodies like Darul Qazas as evidence that Muslims are making their home in these secular states, particularly India, and that they see themselves as citizens who are in for the long haul. This way of thinking about Islamic bodies represents, I think, an important challenge to contemporary public and scholarly discussions about Islamic practices in secular states. So that's the first way that I think that this book challenges the way that we currently think about these issues. The book also challenges our current thinking in a second way. It unsettles how we understand how Darul Qazas relate to the state legal system. Because Darul Qazas, along with Sharia courts, Sharia councils, and other similar bodies across jurisdictions, are often thought of as a parallel legal system and completely separate from state courts. But the book actually offers rich evidence for how state courts at times rely on, endorse, and even enforce the decisions of Darul Qazas. In fact, the book provocatively characterizes Darul Qazas as sites of appeal from state courts. Again, these findings will surprise many and unsettle many widely held beliefs about how these Islamic bodies relate to the state. The book makes these and other provocations in the course of its overarching argument that the Indian secular state both loves and hates Islamic non-state institutions like Darul Qazas. And the argument is that both the state's love and the hate are symptoms of the state's need of these Islamic institutions. Now, make no mistake, the idea that we should think of the Indian state as loving Darul Qazas is a very startling one. Even the idea more generally that we should think of any state at all, as loving, hating, or possessing emotions will be startling to many. But the book addresses this challenge head on in the conclusion and makes the case for why it's both possible and useful to think of states as having emotions. I'm broadly convinced by this argument, but I will ask a question and then make some comments on this aspect of the project. My question is, how do we test for or assess a state's emotional condition? I want to offer an answer by way of comment. Philosophers like Margaret Gilbert and Simon Blackburn suggest tests for when we can say that a group or an institution, like a state, holds certain beliefs. Those tests for when a group or institution holds certain beliefs, I think, can be extrapolated to test for when we can say that a state manifests or expresses certain emotions as well. The argument about the Indian state's love, hate, and need is made in modest and tentative terms in the book. But I want to suggest that it can be made more assertively if this already multidisciplinary project draws on the insights of Gilbert, Blackburn, and other philosophers on group agency. So I'll end there with that comment. Thank you for this opportunity again to discuss Jeff Redding's A Secular Need. If the pandemic is a portal, as they say, then it seems to me that this book represents precisely the kind of perspective shifting work that we should pay close attention to. So I recommend it to all of you in the strongest possible terms. Thank you.
Thank you, Farah. Now let me turn to Rohit. Rohit, your work is focused on history, constitutionalism, and decolonization in India. We're keen for your thoughts and perspectives.
Thank you, Sarah, for inviting me to join this panel. I want to second Farah Ahmed in congratulating Jeff Redding on writing a tremendously compelling, deeply researched, ethnographically sensitive, and theoretically provocative book. It's a work of over 2 decades in the making and is written across the US, France, Pakistan, India, Singapore, and Australia. The book therefore reflects both the transnational influences and questions that it confronts, and while being centered in India, makes an important theoretical innovation in conceptualizing legal pluralism and secularism that are applicable more widely. More importantly, this is a book that's born out of deep love for the people and societies of South Asia, an emotion that's reflected in both the care and attention given to the voices of South Asian actors, many of them women, and in the urgency of addressing the rising conflict around the religious lines in South Asia. In some ways, the book is a response to Partha Chatterjee's sort of provocative challenge from some years ago, where he argues that much of what we take to be as normative theory is really extrapolated from the historical experiences of Western Europe and North America. Jeff invites us to look back at South Asia as a site for building theory, not just as a site for gathering empirical data. He makes an interesting argument that South Asia, India in particular, is an important site for thinking about Islamic law. In contrast to, say, jurisdictions like the United States or the United Kingdom, where non-state Islamic legal actors are a relatively new entrant on the scene, and also distinguishing it from Islamic states or states that have an official status to Islam, like Saudi Arabia or Iran, where the questions, where the embeddedness of the state and religion are more clear. India, as he reminds us, is the third largest Muslim state in the world. It is importantly a non-denominational state, which recognizes and exists alongside non-formal and non-state Islamic legal actors. At various points, Jeff suggests that Indian secularism is a kind of left-handed jurisdiction where the religious non-state enjoys a position of relative advantage vis-a-vis the secular state. He also challenges us to sort of push against views which have seen the existence of non-formal spaces as a site for resistance to the larger secular state, and shows how they're imbricated within each other. This work is particularly important at a moment where tensions along religious lines are heightened in India and follows both sort of legal exclusions and targeted violence against South Asian Muslims. While reading Jeff's book, I was reminded of W.H. Auden's poem, Law Like Love, and I'm just going to read out 2 paragraphs which I think frame Jeff's work really well. Law Like Love is a set of reflections on what the law is, and Auden sort of ventriculizes a range of different speakers. So he says, law, says the judge as he looks down his nose, speaking clearly and most severely. Law is, as I've told you before, law is, as you know, I suppose. Law is, but let me explain it once more. Law is the law. And in the last paragraph, Auden responds, law is like love. Like love, we don't know where or why. Like love, we can't compel or fly. Like love, we often weep. Like love, we seldom keep. The first part of Jeff's book really complicates what we understand to be the legal archive. So as Jeff says, for many people, the point of law is to tell people, whether working for the government or being private citizens, what they can or cannot do. As a result, law, according to this view, should embody clear commands and clear rules, allowing the best intentioned, the best educated to behave and plan their lives. For someone following this point of view, and this is much of the legal profession in academia, the law is found by going to a law library and reading legal textbooks and looking at the given jurisdiction Supreme Court cases. In fact, the more Supreme Court cases there are, the clearer the precedent is, the clearer the law is. Jeff pushes the idea that the law, particularly in this case, the sort of relationship between state and Islamic legal systems over the subject of the family, is rarely a discrete, separate, or univocal identity. The law can do very different things. It is both the kind of high command of the state, but also exists in a number of decentered spaces, not just the sort of non-formal court system, but also within people's homes, in the market. And therefore, the legal archive or the legal library is not just in a physical library, but is read through a variety of sources. So one of the most evocative bits of Jeff's book is really his engagement with individuals who are navigating the kind of divorce system in a non-formal space. And by looking at it, what he shows us is that even in this sort of non-formal, non-state space, we see the emergence of certain kinds of procedurality, which mimic state forms or provide an alternative to state forms. The second part of Jeff's book is really focused on love. And I just want to read out 2 quotes. Jeff says, secular legalism in India is both complex and paradoxical, encompassing hateful othering, absorptive love, and needful dependency. He asks, can a secular state hate? Can it love? Can it be needy? And then in turn resentful and romantic. The narrative of love comes up in several different ways. The first, of course, draws on the larger work on religious nationalism in India, where scholars ranging from Peter Van der Veer and Faisal Devji have talked about how Hindu and Muslim nationalism through the early 20th century have often been imbricated with each other. One needs the other to survive. The narrative, a kind of progressive narrative, is often framed to familial idioms, that of fraternity or brotherhood. And this also plays out in all kinds of cleavages where disputes within the communities are often framed as a family feud. It's a sort of existing trope in Bollywood films where brothers who are often raised in different faiths sort of separate, feud, and then come together in the end, often reunited through the figure of woman, the mother. So Jeff shows that as Farah mentioned, in India, the non-formal legal systems and the formal state need each other to exist. One can't exist without the other. The state's affection, the state's response to the Muslim community is both through a form of radical exclusion, where there's an attempt to sort of remove preferential practices that are seen to preserve aspects of Muslim identity, but it's also seen as a kind of radical absorption where Muslims have to be brought in to a certain kind of centralized legal fold. So I want to sort of ask Jeff a question on these three terms, thinking about love, hate, and need. Need is not just an affective term. In fact, what Jeff suggests, the secular state and Islamic legality need each other in South Asia. Need is often figured through material conditions. And as we know through the work of a range of scholars starting from Friedrich Engels, the family itself is an economic unit and not just an affective one. I was hoping Jeff can talk about the underlying political economy that lies at both the engagement with Islamic institutions and the kind of love-hate relationship between Hindu nationalism and Islam in South Asia. I hope it can help answer why is it, and Jeff shows, Muslim women go to non-formal institutions in such large numbers. Are there economic interests that they can better protect here than in the court? And I look forward to Jeff's answer and would want to encourage all of you to read the book. As Farah said, it is both a provocative and a very compelling book and much needed for these times.
Thank you, Rohit. And thank you to both panelists, Farah and Rohit, for your very thoughtful comments and questions. So now it's only fair that I give Jeff a chance to say something.
These compliments and comments are both appreciated, and I really want to thank Farah and Rohit both for engaging so thoroughly with the book's evidence and the book's arguments as well. So I think one thing that's common between Rohit and Farah's comments is their attention to my argument about love. And I'll have to confess that this is maybe one of the more difficult issues that I struggled with in writing this book is locating love in the politics of the secular state vis-a-vis its Muslim interlocutors, and specifically Darul Qazas. And I think that this asks us to think more thoroughly about what love is. I think many people have a pretty clear notion of what it means to hate someone, but love is maybe a more complicated emotion to puzzle through. And just to take up Rohit's invitation, or Bollywood invitation, you know, in much song emanating from South Asia, there is a discussion of three different kinds of love. So pyar, ishq, and mohabbat. And I think it's a valid question and a kind of a further inquiry for me as to what kind of love that we see here. And I think the kind of love that I'm identifying is one that is on a spectrum actually with hate. And I guess I would identify pyar as that kind of love as operative here. A kind of love which absorbs, it is uncomfortable with the other, and so tries to absorb the other into itself. So it's interesting for me to hear that love features so prominently in these two perceptions of the book. And I would just say that, you know, I think this is something for us all to kind of puzzle through. I think a kind of love is operative here, but we need to be careful about how we describe that love, how we translate it, and how we see it in constellation with other emotions like hate and then also need. Let me also just speak a little bit to the archive and to the political economy. So the archive, you know, and Farah's question, how can we determine what you know, the emotional state of a state? I think that is an archive question, and I think Rohit also asked some archive questions. Let me just say that there is a lot of archival complexity that this book deals with, but the emotions actually are fairly on the surface, for better or worse, in the state's archive. So one of the things I talk about is the recent triple talaq decision, the Shaira Bano decision. And in that decision, the state's emotions, its feelings, the different litigants' feelings and emotions about the practice of triple talaq are all over the litigation. And I really don't think that we can understand this litigation and really situate it in the larger political, economic, affective, situation in India without paying due attention to that emotion. And so at one point in the litigation, the Chief Justice remarks that the entire nation is up in arms about triple talaq. Finally, I'll just say something too about other kinds of political economy operative here and why Muslim women, some Muslim women decide to pursue divorces through Darul Qazas. This again goes to the material conditions affecting the Indian judiciary more broadly, namely the overwhelming caseloads. So these overwhelming caseloads create all sort of burdens, not only for the courts, but also for ordinary citizens in India. It's very hard to litigate in Indian courts unless one has access to a lawyer, and there's many costs associated with that. And also one has to have a great degree of patience. So litigation on civil matters, including family law matters in the Indian system, can take years. And the cost of engaging a lawyer for those numbers of years can be really considerable. The Darul Qazas are not absolutely costless. There are time delays associated with them. But in general, they are seen, and they were seen by the people that I interviewed, as being less expensive ways of achieving the result, namely a divorce. So I'll just end there and open it up to questions and comments from the audience.
Thank you, Jeff. Now it's my pleasure to open the forum to questions. And I've already got some questions piled up here in my chat function. So let me read the first one for you. How important is foreign policy intervention by other democracies in moderating the secular balance in India?
I addressed this question indirectly in Chapter 4. So I think Chapter 4 situates the divorce politics within India and the ways in which Darul Qazas perform certain key divorce functions for the Indian state within a larger geopolitical discussion in which India has been involved in for a long time, both in colonial times and post-colonial times. What's interesting to see about the Indian discussion of family law is that it is a deeply comparative law informed discussion where there are many on the surface apparent concerns by Indian policymakers that their family laws be so-called modern. So in numerous family law reform efforts that I detail in that chapter, you can see the state's concerns about what countries in Europe, including the UK, but also other regional actors like Pakistan, how their views and decisions about family law should impact India's decisions. This is also really all over the surface in the Shayar Bano decision, where many newspaper reports surrounding this litigation concerning triple talaq focused on the fact that countries like Pakistan have banned triple talaq. Why can't India? So I don't think foreign policy actors have to intervene. They're already present in a really tangible way in these discussions.
Now, I have two more questions which are related. So maybe I'll read them both out to you and let you deal with them either together or separately. So the first is, how much do such courts help, quotes, bring in the people, close quotes, to the project of governance, but not on the terms of the alienated rational bureaucratic state, but of the Muslim community? And then the second question is, how then does this historical trajectory fit into the broad question posed about the Indian state and secularism most sharply by Gayan Pandey? Can the Muslim be an Indian on their own terms, not on the terms of the majoritarian Hindu?
This is an important set of questions, and it brings me back to something that Rohit said, namely about the ways in which procedure, as I detail in the book, in these Muslim courts or Darul Qazas, I think mimics is the word that Rohit used. What I want to argue, and what I maybe need to state more explicitly, is I think it's not super helpful to think about differences all the time. So I don't see the Muslim Darul Qazas as necessarily mimicking the state. I see the state as mimicking the practices, the dispute resolution practices that you find in society and informal spaces more particularly, informal legal spaces more particularly. So there's a way in which people are, like Muslims, are being brought into the state, but there's also, I think, ways in which we have to think about the state being drawn into other forms of legality that the state is not necessarily the author of itself.
Thank you. Now I have another question, a question for Jeff. What understanding of secularism do you deploy? Being secular as an identity, secularization as a process, and secularism as an ideology all hold very different connotations depending upon the context, and thus the understanding of what need is very different. Also, what is the relationship, if any, for Jeff, between non-state sovereignty of the Muslim courts and the state project of secularism/secularisation? Other panelists' views are also welcome.
I see secularism as an intersection of a lot of different discussions, concerns, politics, affects, and emotions. So I tend to look at how secularism occurs on the ground rather than how it is theorized, in academic circles and so forth. And so I make that sort of commitment to looking at secularism as it is operationalized by ground level actors, including non-state courts and state courts in my book. So I tend to see it as a site of intersection of practices and not something that one can necessarily anticipate or theorize very broadly. One can theorize, but I think one has to be careful about how broadly one takes the lessons of one secular society to those of another.
Go ahead.
I just wanted to segue a couple of places Jeff's book sort of addresses this. So one, of course, is there's a sort of constant narrative in South Asia and other places that secular legal systems do more to protect the rights of Muslim women or women in general than religious systems do. And at a kind of formalistic reading, when you just look at the text, that might be true. But what Jeff shows us is that Muslim women are more likely to go to the non-formal dispute resolution systems because not only are they accessible, they're better able to enforce equitable judgments than the secular forms can do. So what his work shows us is that we can't sort of make these decisions based on a narrow reading of legal texts, but we have to look at what is it that individuals do to secure their own sort of direct needs.
Thank you. What is the relationship, if any, between non-state sovereignty of the Muslim courts and the state project of secularism, secularizations? How does the existence and operation of Darul Qaza affect questions of identity and community for Indian Muslims vis-a-vis how they view themselves as citizens of the Indian state? And finally, according to your work, what was the experience of women going before these Muslim courts? What kind of access to justice did they enjoy before these courts? And how did that impact on your characterization of the relationship between the secular state and citizens?
So let me focus on the last question, namely the individual Muslim women whose journey through different legal systems I narrated at multiple points in the book. So let me just, on this note, emphasize that Darul Qazas are not the only site where Muslim women seek to adjudicate their concerns vis-a-vis families or in other domains outside of the state. So there's all sorts of venues which people use, some of them explicitly religiously identified and some of them not so explicitly religiously identified. So the first forum that people often choose are their families, and in family law disputes, both seeking advice and counsel from their own families, but then using their families as interlocutors with the husband's families. This goes back to I think the larger political economy question that Rohit asked, in which I think we really need to acknowledge more broadly when theorizing about state dispute resolution processes. These were not designed ever to resolve all disputes. If I have a dispute with my neighbor, the last place I would probably typically end up is in a court. I would first go and talk to the neighbor. If that didn't work, I would maybe then talk to their neighbor and determine whether this had been a pre-existing problem, whether I was perhaps being unreasonable. Right? There's all sorts of ways in which we use interlocutories to resolve our disputes outside of courts. And if courts got involved, were the site of first instance of these disputes, there's no court in any nation anywhere which would be able to handle that dispute load. So again, Muslim women often end up in these darul qazas after several other attempts at resolving the family dispute or the attempt to get a divorce out of their husbands have failed. And in these darul qazas, families are often brought in as well, right? So I trace in chapter 3 in the book the one divorce case of this one woman who I had the good fortune of meeting, and her extensive interactions with a darul qaza in Delhi. And one of the things she emphasized is that that her father and other people, including an auntie, as she described her, were there and serving as advisors and kinds of counsel, if you will. So, I mean, I think this also goes to broader issues as to how we theorize different concepts, like secularism, like law, and the rule of law as well. These are not, concepts which we can necessarily anticipate how they instantiate, right? So the father and the auntie were counselors, for that situation. So again, I'm seeing all of this as how it is operationalized and understood on the ground, and trying to theorize from the bottom up.
Thank you. So unfortunately, we're out of time. So I'd like to draw this session to a close by thanking you all for joining this very important panel discussion. And particular thanks to Jeff for writing the book and for presenting tonight, and to our panelists, Farah and Rohit, for your very insightful comments. So good night to you, and thank you for joining.
Good night, everyone.